next matter to come before the court this morning is the state of Ohio versus Adrienne Beverly. The state has waived argument in this case, so Attorney Beverly, it will be just you this morning. We'll have you 15 minutes to make your case, and we have read the briefs from both parties, and we're ready to proceed when you are.
Thank you. Good morning. Please, the court. First things first, welcome to your new home. Second thing, Judge Hensel, remember you asked for this again, so congratulations on your victory. If it please the court, I'm Mark Ludwig. I have the privilege of representing Adrienne Beverly, even though you'll notice on the cover of my brief, I can't spell her name correctly. It is A-D, not A-N-D. I hope that will be corrected when this court reverses in its decision. There are two errors. One is the acceptance of the guilty plea, and two is the sentence imposed. And each of them necessarily includes the amount of restitution. Now, in terms of acceptance of the guilty plea, this record shows this defendant does not acknowledge that she understood two constitutional rights: the right to confrontation and the right to compulsory process. This is transcript 15 through 17. The state tried to turn this into, I was complaining about the trial judge ably doing more than one person at a time. That wasn't the first time I've seen that, and that's not the first time I've been a party to that. It's not a question of how many are in the auditorium that you talk to. It's a question of two things. One, did you mention every right? And two, constitutional and other rights, did you mention them? And two, did each person individually acknowledge they understood? I don't care if you want to do 100 people in the room. Some people think that makes it go faster. Others think, well, you're still going to have to go back to each one and say, number one, did you understand that you have a right to confront witnesses? Number two, did you understand the right I just explained to you? Did you understand to 100 people? That's going to take as much as maybe doing them one at a time, but how a trial court chooses to do that is fine. It's when you do it and you don't get an acknowledgement from the defendant that, yes, I understand I have a right to confront witnesses, and yes, I understand I have a right to compulsory process. This record shows that none of the three that were done at that time was individually asked if they understood those two rights. That's it. End of complaints.
Counsel, we haven't, or at least I haven't read the record yet. So, and when we look at the transcript, are we going to see the judge just saying, you know, you have the right to have, right to cross-examine, compulsory process? Do you understand that right? Does she say that to all three? Is that what you're saying?
Yes.
Okay, and then does she go back and say, Ms. Smith, Ms. Moore, Ms. whatever, do you understand that?
What the judge generally did was, you have explained the individual right, and then ask each individual to all three, and then ask each individual, Judge Carr, did you understand that?
Right, right, and that's what I'm saying, that she did that, I don't know who the judge was, but
She,
did that judge do that with the other rights under rule?
yes.
But just neglected to do it with?
I'm not going to accuse anyone of getting enamored of the sound of their own voice, but the explanation that the trial judge gave for the confrontation rights and the compulsory process rights was very detailed. It was very nice, but it was so detailed that when we got to the end of them, we moved on to the next right without asking the defendant. Now,
But what I'm saying is that was contrary to the way she had done it with every other right?
yes.
Okay.
Yeah.
And obviously we'll look at the record.
Yeah, it's 15 through 17 in the November 30th transcript. The state's brief replies, and I love how ably my former opponent could turn a phrase. The state's reply was, it beggars the imagination. That's page 11 of Rick's brief. It beggars the imagination that she didn't understand those rights. Well, as lovely as the phrase is, it's not a question of whether our imagination is sufficient to assume that she understood the rights. Here's how we know she understood the rights. Do you understand what I'm saying? Yes. Okay, let's move on. So that's the guilty plea and what didn't happen. Now, also, as part of that guilty plea, there's a discussion about the amount of restitution that's going to be made. No, I did not say at that point in time, we object to the $4,400. I also did not say we agree to the $4,400. Also, unlike one of the other defendants, my case was not introduced as, in Higgins, one of the others was introduced this way. My case was not introduced as, Your Honor, pursuant to Rule 11F, we have these plea negotiations, and it has been agreed. That was not said. Again, I didn't speak up and say objection, but nobody said I agreed to anything. There was no Rule 11F discussion. And what's the basis in the record at the time of the reference to the prosecutor's diversion program? The basis is, the prosecutor says, in our case, well, I've checked into this and here's the amount. Now wait a minute. 292918A1 says, here's how we know what restitution is. 1, it's recommended by the victim. 2, the offender agrees. The offender agrees. 3, it's in a PSI. 4, there's receipts or other information in the record. And 5, it does not exceed the economic loss. I did not see in that statute the factor of restitution is what the assistant prosecuting attorney says it is. And that's what's in this record at the time of referral to the prosecutor's diversion program. This record does not show, I'm not saying the prosecutor lied, but what I'm saying is this record does not show that there was any support for what the prosecutor said. The second assignment of error is the sentence. Well past time, in March of 2017, after being in the program since November of 15, she's summarily sentenced to 18 months plus the same restitution amount. Let's get the standard of review out of the way first. This one. We said our standard of review is the twofold standard, and that is abuse of discretion and clear and convincing evidence that it was contrary to law, the markup standards, kind of merged together. That's what I argued in our brief. The prosecution agreed in its brief at the standard of review section that that is the standard of review. Now, if we're both wrong, and none of you agree with us, I leave that problem to you. But what we both agreed was that was the standard you should apply. Then, during the body of the brief, my able opponent argues, no, this is plain error. Well, wait. Which was it? Do you agree that it's abuse of discretion and clear and convincing? Or do you argue, no, the standard of review is under the plain error standard? You can't, in your head of your brief, say, I agree that that's the standard, and then in your body argue a different standard. I don't think we should encourage that.
Well, the plain error, as I understand it, was just specifically that you didn't object to the restitution amount. So plain error should...
But what he is saying is that that is the review standard that you must apply, is plain error. No, wait. No, he didn't agree to that. Secondly, in terms of the word plain error, has this court's reading of a record come down to checking whether or not the word plain appears before the word error in an assignment of error? I don't think so. He cited Ford, the Ford case. In the Ford case, the assignment of error does not use the word plain. That's paragraph 4 of the Ford case. Yet in paragraph 10 of the Ford case, this court found plain error. We have reduced the plain error argument to a sword that cuts off rights instead of a shield to, I wasn't fairly warned of what you were talking about. I don't think I've asked in 44 years, I don't think I've asked this court to create arguments for me. I think it's pretty clear what we're complaining about in the sentence, okay? That there was an abuse of discretion and clear and convincing evidence shows the sentence is wrong. That sentence includes restitution. We're asking this court to use the agreed standard of review. We added to this record, and the state's brief recognizes, we added to this record instances of the original entry into the program. On November 2nd, these are part of the record, she signs an agreement where the prosecutor's program says to her, if you fail in completing this program, your constitutional rights will be restored to you. Her entry into the program doesn't warn her that if you don't keep these rights, if you don't comply with the program, you'll be tossed from the program and immediately sentenced. That's not what she was told on November 2nd in writing. She was told, here's your rights you're waiving by wanting to enter the program. If you don't successfully complete the program, your rights will be restored. And that's all it said. It didn't say a thing about you'll be immediately sentenced. It also told her the requirements of this program in paragraph 9 on the requirements portion told her you'll be in this program a minimum of 6 months to 1 year. That's paragraph 9 of the requirements section. Paragraph 11 of the requirements section told her, right now the amount of restitution is, quote, pending, close quote. Paragraph 12 told her, look, we can extend this program 6 months if you've made your restitution and you still owe us court costs. So what she's told is it's 6 months to 18 months if it's extended, and she's told that in November of 2015. Well, here we are. 3 years later, she's been tossed from the program in March of 17 after we appear for a status. This is clear in the record on that transcript. We appear for the status, not a termination hearing. We appear for a status. We were noticed for a status. And the visiting judge at that point, as she often had to do over the years, hit me upside the head with a board, she said, look, Mark, she's out. This is in the transcript, page 3 through 2817. She's out. You can prolong her misery by requesting a continuance because of you weren't really noticed this was a termination hearing, or you can go forward. What do you want to do? Gee, what I want to answer in front of my client is, I'd like to prolong her misery, Your Honor. Look, the point is not the immediate notice problem. The point is that this prosecutor's diversion program is assumed to work like an IILC or a probation. And that is, when you violate, you will be immediately sentenced. I've got no problem with that concept if you tell us that up front. The forms that you see
But
used...
counsel, wasn't that told to her when she pled?
No. No, I don't think it's made clear to you that now your option is different than what you were told during your interview. Now your option is, if you don't live up to it, we're going to sentence you. So we can reread the transcript of the plea, but that's the November's 30th transcript. We can reread that, and we can, don't you dare shake the judgment entry at me until you show me that a defendant has seen it. And you know that doesn't take place in this common pleas court. They are not sent the entry. And I won't tell you whether I give my client documents. I think that's privileged. So you can't prove it through me. That entry is never served on a defendant. Shame on us. It must cost money. The mail will come back. I don't know all the reasons why they don't do it. We're going to presume that the assigned lawyer whose job is done at sentencing, Ed has the job to provide the entry. If it please the court, the proper result in this case is to vacate the plea and issue an order that she's done. Now, if there's money owed to some entity that wants to come get her, come get her. And that's what the visiting judge said at the plea. You know, we can drop her out of the program, and if she doesn't make restitution, and then she can deal with that battle later. $4,400 for not returning a car on the date it was due.
Sir, you're out of time.
Thank you.
Thank you. Thank you for the presentation today. The court will take the matter under advisement and issue a written decision which will have both sides as well as posted to our